Parliament's ad hoc committee will continue hearing public submissions on alleged criminal infiltration and political interference in the justice system. Yesterday, 3 civil society organizations spoke on Minister Senzo Mchunu's directive to disband the political killings task team. Today, MPs will hear from 4 more individuals. Newzroom Afrika's Zoleka Qodashe is live to us at Parliament, and she sat through those submissions yesterday. And Zoleka, good morning. One of the important things that Accountability Now, one civic society organization, had to say to the ad hoc committee is that what the country needs is a body outside of the control of the executive, completely separate from the control of the executive, to deal with corruption.
That's correct, Michelle. Good morning, and good morning to the viewers. And what essentially is expected to happen, and what we saw unfold yesterday, is that these bodies assist the ad hoc committee really sift through truths and mistruths, and also give their recommendations on what they think would be best for the criminal justice system, as well as what they have observed over the years in relation to their watchdog role, in relation to the work of the SAPS, as well as various aspects of the law. And so that is what Accountability Now Director, Advocate Paul Hoffman, Senior Counsel, put to the ad hoc committee, saying that essentially the reason why the certain institutions that are meant to safeguard South Africa's constitutional democracy are susceptible to political interference is precisely because they rest with the executive. In fact, he mentioned Section 179, subsection 6 of the Constitution, which gives the Minister of Justice and Constitutional Development the final authority when it has to deal with matters of the National Prosecuting Authority. And that is what they take issue with. They say that the establishment of a Chapter 9 institution that would essentially deal with corruption, an anti-corruption body as a Chapter 9 institution, would assist in ensuring that the NPA, for example, is safeguarded from political interference. So remember that he also referenced the Glenister judgment of the Constitutional Court, which prescribed, or rather ordered, that that Parliament establish a body in terms of law and legislation that would assist in ensuring that it is not part of the executive and would also deal with corruption matters. So that is what has come out of the testimony, or rather the submissions that were made by Accountability Now. But the common thread, Michelle, is the fact that the executive holds the final authority on a lot of matters, and that the budget for a lot of these institutions that are meant to uphold South Africa's democracy rest with the executive. You look at the judiciary, for example. The retired Chief Justice Raymond Zondo has also brought this up several times, saying that the fact that the budget of the judiciary does not rest with the judiciary and instead rests with the executive is also a cause for concern, because if it rested with the judiciary, it would allow the judiciary to manage its own affairs insofar as its pocket is concerned. And so that is something else that came up during the testimony of, or rather the submissions of these civil organizations. But also, Michelle, the need to reform legislation insofar as it relates to political interference is also something that was thrust to the fore yesterday.
There was also one Chapter 9 institution, or rather a forum called the African Policing Civilian Oversight Forum. So there were several civic society organizations that made submissions, but this particular organization noted something that has come up in previous inquiries as well, particularly the inquiry into state capture. And the finding there, one of the sort of primary and more damning findings against Parliament, was its inaction when it came to certain allegations of corruption against particular individuals. And again, this was brought up in Parliament, that Parliament itself should strengthen its responsiveness to these allegations.
That's 100% correct, Michelle. In fact, it is the submission of those various parties, or the party that was before the ad hoc committee yesterday, essentially saying that Parliament must establish mechanisms to ensure that it is able to track its own recommendations and its own work in Parliament in order to ensure that there's also effective and swift action against those that are found to be against the work of Parliament, but also in relation to various recommendations like the Zondo Commission, and that those people are called to account before the national legislature. But there was also talk about the minister's powers, and in fact, the members of Parliament yesterday were cautioned not to adopt an adversarial approach when engaging with the people that appeared before it to give submissions that will assist the ad hoc committee table recommendations that they will, in a report that they will then hand over to the National Assembly, to Parliament. And so the reason why we also heard from the ISS, for example, is in relation to the powers of the minister insofar as they relate to his ability and the legality of his decision to issue that all-important 31st of December 2024 directive for the disbandment of the PKTT. Now, what was heard there, or what was submitted before the inquisitorial body yesterday, is that insofar as Section 206 and Section 207 of the Constitution, there isn't evidence to suggest that the minister actually intentionally violated or explicitly violated those particular constitutional provisions. But you'll remember, Michelle, that the decision of the minister, because he exercised his powers as an organ of state, fall as or can constitute administrative action. And that is found in Section 33 of the Constitution. What administrative law does is that it recognizes the that members of Parliament or organs of state must exercise their role and functions in terms of policy. And because of that, what administrative law does is that it ensures that exercise of policy and implementation of policy is procedurally fair, it is lawful, as well as that it does not violate any fundamental human rights or any rights. And that is why that is important, and that is also regulated by the Promotion of Administrative Justice Act that is known as PAJA, that essentially ensures that members, or rather organs of state, abide by the law and they do not take decisions or make decisions without consultation. So that's also a matter that we expect will be traversed when members of Parliament gather again today to hear further public submissions that will begin at 11 a.m. Michelle.
Zoleka, thanks very much indeed for that. It's 9:22, so 8 minutes or so until the Madlanga Commission of Inquiry resumes in Pretoria.